It is unique. It is novel. Edward Yates is sitting in jail this morning. For 5 weeks now, his attorneys have been trying to convince a jury that he doesn't deserve to spend the rest of his life in prison because he never could have committed this murder, they argue. He's simply too large.
For the past 2 days, Edward Yates has been on the witness stand.
Did you murder Paul Dunsack?
No, I did not.
Paul Dunsack was Yates' former son-in-law. He and Yates' daughter were in the midst of a messy custody battle. Dunsack was on the phone with his new fiancée when he was shot.
Suddenly he started to scream. He said, oh no, and then he stopped speaking.
Prosecutors say Yates executed a commando-style slaying, then jumped in his car and drove 21 hours straight to his mother's home in Louisiana. At the time, Yates weighed 285 pounds. He's 5'8". Yates' defense attorney is arguing there's no way a man of that size could pull off such a crime.
In bright daylight in August, the fat old man's running and nobody sees him.
Yates' doctor testified that bounding up a set of stairs would have made him short of breath and so shaky he couldn't have accurately fired a gun. And he told the court there's no way Yates could then drive for 21 hours.
I would find that very difficult in someone with obstructive sleep apnea who's morbidly obese.
However many clever defense lawyers out there, you're going to get clever defenses. And sometimes it's successful if it has a ring of truth, if it's believable to a jury as to preclude or prevent a defendant from doing what he's accused of doing.
Back in 1977, 15-year-old Ronnie Zamora argued he was insane when he killed an elderly neighbor because he suffered from television intoxication. It didn't work. In 2002, a San Francisco man who dismembered his landlady was found insane after claiming he was sucked into the Matrix. And remember the Twinkie defense? The legend is a jury gave a light sentence to the man accused of killing San Francisco's mayor and supervisor after a psychiatrist said Twinkies made the killer more depressed. In truth, the case wasn't nearly that simple, just as the fat defense may not be what this case comes down to.
It may actually come down to Yates' alibi. There are no eyewitnesses, not much physical evidence in this case, but Yates' sister has testified that her brother called her and asked her to lie for him and say he was in Louisiana at the time of the shooting. Yesterday in court, the prosecutor played a wiretapped phone call that Yates made to his sister in which he tried to coordinate their stories. His wife, by the way, is also charged in this case because prosecutors say that she lied to investigators. Yates faces life in prison if convicted, and it's expected to go to the jury next week. Robin.
We have more on this case, so joining us now is the defense attorney in the case, Walter Lesnovich.
Morning.
Good morning to you. Your client was, he's 5'8", he was 299 pounds when the crime was committed in 2007. As we saw him on the stand.
2006.
Okay, was committed in 2006. When we saw him take the stand this week, and he lost, against your advice, he's lost 40 pounds.
Right.
But you contend he was too overweight to commit this crime?
Well, the weight...
Have you ever heard this before as a defense?
I have not. The weight is just a part of it. With the morbid obesity comes diabetes, hypertension, sleep apnea, the inability to sleep properly, the inability to function during the day. All of these ailments, which are common for morbid obesity, interfere with his ability to do this.
The coroner's report says the shooter shot the victim one time in the leg.
In the leg, at an upward angle.
Okay. Then the shooter goes up 4 steps and shoots again and again and again. 4 steps. You're saying he was too overweight to go up 4 steps?
He could go up 4 steps, but could he then maintain the pistol straight and not miss and shoot straight into the person? That's a tough shot. It was more than 4 feet away, no powder burns.
All right, but the prosecution, claims he's a former military man and that he did admit to owning a gun and he shot a snake at one point, admitted to shooting a snake, which is, you have to be an accurate shot to be able to do that.
It was 6 inches away from the snake. That's nonsense. The snake is nonsense. And as far as the military, he had 30 years as a computer expert, a Vietnamese language expert. He is legally blind without his glasses, so he could not be a combat soldier.
The prosecution also contends that your client went online, visited a website that's called How to Commit the Perfect Murder. He also went on sites researching gun silencers and how to pick a lock. How do you explain that?
It's all circumstantial evidence. What do you have in your library? What have you looked at on your computer? He also bought a book called How to Build a Nuclear Bomb, but he didn't build one. It's circumstantial evidence. It's his interest, his hobby. He's retired, spends way too much time at the computer. Classic couch potato.
We heard, and as Kate was talking about, his sister, who said she really didn't want to testify against her brother, and that, in fact, she said that he told her, "I want you to lie and tell them I was here." He was afraid they might blame him for what happened. It's a hard thing to testify against your brother, but I think it's the right thing to do.
Her whole thing is that she said he was there on Thursday, as opposed to yesterday, which was Wednesday. We also have an eyewitness, unrelated, who said he saw Ed and his car on Wednesday in Louisiana, the day of the murder in New Jersey. So she is mixed up one day to another day. She said that he was there at the proper time for months after being arrested in the police car on the way to being booked. She said, "Oh no, what you're saying, officer, is true, not what I've been saying."
But the wiretaps, and you can hear them going back and forth. She's talking to her brother about the timeline.
Right.
They're going over it again and again and again. It's almost like they're trying to get their story straight.
He is trying to get her to come to understand what day of the week it was. Nobody's using August 23, August 24. Nobody's precise in this conversation. One conversation, he says, no, it was Tuesday. He actually didn't get there Tuesday. He got there Wednesday. They're all mixed up on which day.
But the trial began in September.
Yes.
Where does it stand now, and when will the jury get it?
They'll get it Wednesday. Wednesday is summation. We're recessed because of Election Day. The court's closed early next week. It'll go to the jury Wednesday.
Of course, a lot of people are interested to see how this will turn out. Walter, thank you very much.
You're very welcome.
Appreciate you coming in.